Some more news today in the Karen Reed case, although a lot of people are still harping on the news that came out yesterday, and that was the order and very short opinion issued by Judge Cannoni regarding Dr. Crosby. Now, you will all remember when it came to Dr. Marie Russell, despite her 30 years of experience as an ER physician, diagnosing and treating dog bite wounds, and her extensive experience as a forensic pathologist performing autopsies or supervising autopsies, she still had to undergo a 2-day Daubert-Lanigan hearing in order for her to be eventually found qualified, but only by a very close call. That was Judge Cannoni's words, and in a very extensive opinion why she eventually came to that decision. Well, when it comes to Dr. Crosby, who's not a medical doctor, not a veterinarian, not a forensic odontologist, which from my research of the law, that is what is required in Massachusetts, he, according to Judge Cannoni, does not even need to undergo a Daubert-Lanigan hearing. It is so clear that he is qualified and that his methodology is sound, that he is going to be able to give an expert opinion to the jury about the fact that these injuries to John O'Keefe's arm are inconsistent with a dog attack. So that is what came out yesterday. Again, like I said, it really is odd. It's a very odd opinion, and a lot of people can read a lot of different things into that opinion. And what I will say about it is that I think it's an error, and I think that this will be a very strong appealable issue for Karen Reed. So I guess there is some sort of comfort for Karen Reed going into this trial, knowing that even if she ends up convicted, this is going to be a very strong appealable issue. All right, now, before we move on to what we're going to be talking about today, I do want to tell everybody that I am going to be sitting down with Andrea Burkhart this Sunday, March 9th at 11 a.m. Eastern, and don't forget about daylight savings time. We are going to be sitting down and unpacking all the different things that happened in the Karen Reed case recently, as much as time will allow. So definitely join us for that live Sunday right here, Brother Counsel Studios, 11 a.m. Eastern. I'm going to be sitting down with Andrea Burkhart. It's going to be a very interesting conversation. Our first conversation, by the way, myself and Andrea Burkhart. So I'm really looking forward to that, and I hope you all join me there. Okay, so there's two things I really want to discuss today. One of them is the affidavit that was filed by David Yannetti. The affidavit that was initially filed by David Yannetti was to admit Mark Bedero Pro Hack Vice to add the dream team, add to this defense team of Alan Jackson, Robert Alessi, David Yannetti, and who knows who's going to be left to that dream team by the time trial comes. That's right now in front of Judge Cannoni. She has not issued an order on that, at least as I'm sitting here recording this video. So he filed an affidavit, and Judge Cannoni said she needs to see more. She wants some more substance in that to see in that affidavit before she admits Mark Bedero Pro Hack Vice into this specific case. So that's exactly what he did. We're not going to be going through the entire affidavit, but I will tell you, just generally speaking, he goes through his extensive experience in criminal law. He's been around the block many times. He's been a trial lawyer. He has specialized skill and expertise to defend Karen Reed in these type of circumstances. So that's why he should be able to join the team. He also, although he is representing Turtleboy, as we know, but there was some very serious conversations that he had both with Karen Reed and Turtleboy, and he laid out very clearly what the possible conflict of interest is and whether it's waivable, and each side was able to consult with their own attorneys about it. So he's doing everything 100% by the book, which is obviously what the defense attorneys have to do right now, because Judge Cannoni is really looking very carefully at them, especially after what happened with Alan Jackson. So he lays that all out in an affidavit, and most likely she's going to look at this affidavit and she'll say, okay, fine, Mark Bedero is in. I mean, unless she's going to have some issues with him representing Turtleboy and Karen Reed at the same time, and there were some issues that were, or concerns that were communicated to the judge by Hank Brennan. So we'll see. I mean, nothing is certain in this case, as we are beginning to learn. All right. Well, now let's go on to the motion that was filed by Hank Brennan. There is a motion that was filed by Hank Brennan regarding the communications between Karen Reed and Turtleboy, and also Karen Reed and an intermediary, and then Turtleboy. So let's pull up this motion. It's not too long. We'll go through some parts of it, and then I'm going to give you what my ultimate opinion is about this specific motion. So I hope you all can see it. I know that StreamYard's doing some updates, and sometimes I put something up and then nobody can see it. So I hope you can all see this. If not, you'll just see a blank screen or black screen, and you'll see me talking to it. All right, here we go. The defendant, we're going to number 6 here, if you're following along. The defendant has challenged the Commonwealth's evidence in this case to include allegations of police misconduct, claims that the Commonwealth tampered with evidence, and accusations that the Commonwealth has framed the defendant with murder. Following an investigation conducted by a special prosecutor, Mr. Aidan Kearney was indicted by a Norfolk grand jury for 16 charges related to intimidation and harassment of witnesses in the case. Following an investigation conducted by a special prosecutor, Mr. Aidan Kearney, by the way, some people also refer to him as Turtleboy, And some people even refer to him as Dr. Turtleboy. All right, continuing, just so you know who we're talking about. Following an investigation conducted by a special prosecutor, Mr. Aidan Kearney was indicted by a Norfolk grand jury for one charge of witness intimidation and one charge of a wiretap violation. As demonstrated by the search warrants generated as part of the special prosecutor's investigation, the Commonwealth alleges that beginning on or around April 17th, 2023, okay, so April 2023, the defendant took deliberate action to start sharing defense theories, privilege materials, and evidence with Mr. Kearney through an out-of-state intermediary. So Karen Reed was sharing this with the out-of-state intermediary. Again, these are all what the allegations are, that Karen was sharing these defense theories and privileged materials and evidence with this out-of-state intermediary, and then that out-of-state intermediary was then forwarding them to Turtleboy. The Commonwealth alleges that the defendant instructed the intermediary to communicate with her through the Signal messaging application, explaining that it provides secure end-to-end encryption, and instructed the intermediary to forward all information, which included witness information, home addresses, grand jury minutes, autopsy photographs, and generally every piece of evidence that the Commonwealth provided to defense counsel onto Mr. Kearney. The Commonwealth alleged the defendant would put disclaimers or directives on certain pieces of evidence, such as denoting "do not share," and that's in quotations, urgent, do not publish anything from the report. And again, another quote, make it clear he, meaning Mr. Kearney, didn't just get it from us, but don't show the exhibits, just read them. Please tell him not to share the title. It has Iannetti's initials in it, DRY, referring to attorney David R. Iannetti. So those were apparently some communications that she had with this intermediary. Beginning in the summer of 2023. Okay, so that was April 2023. Now beginning in the summer, what time, when in the summer, June, July, August, who knows? But beginning in the summer of 2023, the Commonwealth alleges the defendant and Mr. Kearney would directly communicate on a regular basis. So at this point, they just ditched the intermediary, and now, according to the Commonwealth, according to Hank Brennan, they now started talking directly with each other. Call detail records from Mr. Kearney's phone revealed that the defendant's phone number and Mr. Kearney had 189 phone calls between June and December 21st, 2023, communicating for an excess of 40 hours. So I guess we have the dates there. So beginning around June 2023, they allegedly spoke for over 40 hours. This was reported to be in addition to frequent text and phone communications made through the encrypted Signal application. Additionally, prior to publishing posts on his platforms, Mr. Kearney would seek permission from the defendant or her counsel. On July 14, 2023, the defense filed an affidavit of Aidan Kearney in support of defendant's motion for recusal and disqualification of Justice Beverly Carnoni. Not very clear what that's doing in the motion, but it's in there. Call detail records from Mr. Kearney's phone also revealed that phone numbers associated with Attorney Iannetti and Attorney Jackson communicated with Mr. Kearney at least 29 times in 2023. So now, not only is there communication between, again, these are all the allegations, not only is there communications between Karen Reed and Turtleboy, but also between the attorneys, Iannetti, Jackson, and Turtleboy, at least 29 times in 2023. Now, why does this all matter? Why in the world does this all matter? Can't Karen Reed talk to anybody that she wants? Let's say she is talking directly to Turtleboy. What's the big deal? We know that she sat down with Gretchen Voss. We know that she sat down with Ted Daniel. No problem. So what's the issue? And in fact, even part of Hank Brennan's motion for sanctions, he has no issue with Karen Reed talking to whoever she wants. He only wanted a gag order against the attorneys. Well, here we go. This is where he's going to lay out his argument. A clear inference. Now, remember, when we use that word inference, you have to remember how Judge Carnoni sometimes deals with attorneys who make inferences, as we saw in the last hearing when Alan Jackson was making some reasonable inferences. Okay, but a clear inference can be made that the parties directly encouraged Mr. Kearney to continue personal attacks on witnesses and their family members, including juvenile children, with a sole purpose to embarrass, intimidate, harass, and deter these individuals from testifying. Mr. Kearney publicly stated that the motivation of his actions was to prevent this case from ever going to trial. So, a clear inference by the fact that they are sharing information is that not only was Turtleboy on his own accord, that he decides to get a little crazy and start to intimidate witnesses. It wasn't just him going off the rails. It was actually at the direction of Karen Reed and maybe even her attorneys. It has been represented to this court by defense counsel Timothy Bradle on behalf of Mr. Kearney that there is an long-term implicit mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant. Motions and affidavits filed by Special Assistant District Attorney Cosgrove make clear that the information produced by produced from both phones are likely to be evidentiary and relevant. The Commonwealth's motion is made in good faith. The Commonwealth intends to introduce evidence of the defendant's statements and actions to intimidate witnesses from testifying against her as evidence of her consciousness of guilt. So this is where it all comes down to, because who cares about all these communications? Well, this is why. Because Hank Brennan's going to argue that if he's able to see these communications, and these communications suggest that Karen Read was actually at the center of all this, or maybe her attorneys, and they were directing Turtleboy to go intimidate, harass, or deter these witnesses, well, then we can then use that. Hank Brennan's going to go then use that to the jury to show, why would she do that? Why would Karen Read try to intimidate these witnesses who are going to testify against her? It must be that she has consciousness of guilt. Because she's guilty, she doesn't want these witnesses to testify. And that's why. So therefore, that's the relevancy of all of these text messages and communications. And that's why he wants all of them. So this is my thought about this motion and then discovery in general. When it comes to discovery, generally speaking, discovery is very wide open. We have liberal discovery rules, which allows each side to discover and requires the other side to produce a lot more information that would necessarily be admissible in trial. That's just part of the game, because you have to sift through the discovery to see what potentially could lead to admissible evidence. That's the point of discovery. Not everything that you discover do you show in court. That's just the nature of the game. So discovery rules are intended to be very liberal. But then the question is, where do you draw the line? Where do you draw the line by this is just being very liberal in discovery, and this is already an invasion of privacy? This is already what we call a fishing expedition. You probably heard about that term from before. So is this a fishing expedition or not? Where exactly do you draw the line? So if you can make some sort of argument that there is some reason, some good reason or solid basis that you want to see certain additional material, which could eventually lead to admissible evidence, which in this case, Hank Brennan is arguing is consciousness of guilt, which is admissible. Definitely evidence of consciousness of guilt is admissible. Well, then that's why he's arguing we should be able to get all of these records. Now, you will recall that the defense wanted to get the reports and all communications as it relates to the Sandra Birchmore investigation. Right? We remember that motion that was argued. Elizabeth Little argued that motion. There was a number of different items that she was requesting, a motion to compel the production of those items. And amongst them were these communications between some of the same investigating officers on the Karen Read case who were also investigating the Sandra Birchmore case, where there is definitely a lot of very serious allegations of cover-up and conspiracy in that case. So don't you think that that's also a good basis to be able to discover that material? That can be definitely very illuminating for this case, to see what exactly these same investigating officers who are going to try to present themselves as just honest, good public servants. And if you can show that in these other cases, they also were acting corrupt or trying to cover things up or look the other way, well, then that would definitely be relevant in this case. You can impeach them on the witness stand. You can use it as argument to the jury. So you will recall that argument. And what did Judge Cannoni rule? Judge Cannoni rules that no, they are not allowed to get that information. And essentially why? Because it's a fishing expedition. There's no relevancy between that Sandra Birchmore case and the Karen Read case. Right? It's too much of a fishing expedition. Discovery, of course, is wide open, but it's just too much of a fishing expedition. Well, using the same type of logic, you would have to argue the same thing applies to this case. Now, of course, when people are saying, oh, you're not comparing the same cases, it's apples to oranges, they're not exactly the same issue. Of course, you're never going to have exactly the same issue. But when you have similar reasons to believe that there may be some sort of cover-up, and then these same exact people who we are alleging, and there's some evidence of some sort of cover-up or definitely questionable activity, then we should be able to discover that. So, discovery is supposed to be wide open. If that's a fishing expedition, then you can definitely make an argument that this is a fishing expedition. This is most likely what the defense will argue. Now, there is a chance, as we've seen, that anytime it comes to any sort of communication that Karen Read's had with Gretchen Voss or reporters or Ted Daniel, they've never objected to the Commonwealth getting all the unredacted reports and transcripts and off-the-record conversations. They've never objected to that because they always maintain that we have nothing to hide. I have nothing to hide. I'm not doing anything wrong. So they may take this stance. They may say, okay, you want these communications? No problem. Go ahead. Knock yourself out. You're not going to find anything there. Now, of course, a good attorney will be able to try to read between the lines and try to be able to use some of the text messages to show that maybe she is cooperating in some of this stuff that Turtleboy is doing. But the posture that Karen Reed has been taking up until now, and her defense team is taking, is that we have nothing to hide. So this is what my suggestion would be. My suggestion would be is that, look, Mr. Brennan, Hank Brennan, has been all about, we don't just comply with our Rule 14 obligations. We comply with even much more than that. We turn over a lot more, right? And that's why he was so taken aback about these emails with the ARCA experts, right? They provide so much more. And he's completely fine with that. So if Mr. Brennan, if that's your posture, that just turn over everything, so then let's have it both ways. You'll get all of the text messages between Karen Reed and Turtleboy. And you know what? If there's a smoking gun there, great. Use that as an argument against the jury, against Karen Reed to the jury. Go ahead and use that as an argument. But shouldn't it work the same way when it comes to the Sandra Birchmore investigation? So if you're all about having all this transparency, so then you should also agree that we should be able to get that information. And so it should be a two-way street. What's good for the goose is good for the gander. And quite frankly, personally, if Karen Reed was really collaborating with Turtleboy, and she was directing him to do these acts of witness intimidation that he's being charged with, then I want to know about it. Sure, I think everybody wants to know about it. If she was the one that's behind the scenes and she's very slyly acting this sly and trying to, intimidate witnesses, then okay, let's put it out to the public. Let everybody know about it. So I'm fine with that. I'm completely fine with the Judge Cannoni ordering all these communications be turned over. Let's see. Maybe there's a smoking gun there. And if there's not a smoking gun, then great. There's nothing to hide. So I'm okay with that. But in the same front, same reasoning, I want all of the materials in the Sandra Birchmore investigation turned over. I want to see what those investigating officers were communicating with each other about that case. The same investigating officers that were investigating this case in Karen Reed's case. So I think it should work both ways. So again, I don't mind having wide open discovery. Let's not call this a fishing expedition. Let's have it wide open, but let's have it wide open both ways. Okay? And then we'll have everything open to the public. No one's hiding anything, and it will all be in front of the table, on the table for the jury. So is that what Judge Cannoni is going to do? Probably not. We'll see what happens with Judge Cannoni. She already ruled on the Sandra Birchmore stuff. So whether you can bring that up again, you could bring it up and say, look, Your Honor, you ruled this way when it came to Sandra Birchmore. But maybe Karen Reed will take the same stance that she's been taking with her communications with the other journalists in this case and say, no problem, go ahead. There's nothing there. And we have nothing to hide. So we'll see what eventually happens with this specific motion. But I just personally believe that everything should be on the table. No one should be hiding anything. Exactly what Hank Brennan is saying. This is what your mantra is. Let's turn everything over. So let's turn everything over. Let's see what the Sandra Birchmore materials also say. All right. Well, that's going to be it for now. So if you haven't yet, please subscribe and like, and then also make sure to join us on Sunday when I'm going to be sitting down with Andrea Burkhart, and we are going to be discussing all the different new events, the latest news, and the latest motions and filings and orders on the Karen Reed case. We'll see you all on Sunday. Everybody have a wonderful, wonderful weekend.